Welcome back. We segue into our big stories this morning. And first on the chopping board, we are contemplating that prima facie case that has been established in respect of the Chief Justice, for which reason now that committee has been set up to delve into whether or not she remains in position. For now, the president has triggered the constitutional clauses and taken the step of suspending the Chief Justice, Gertrude Torkornoo. But there are different sides to the discussion, different takes on it. And joining me here, of course, we have Sweetie Abochi, who will walk us through our guests that we have joining the conversation this morning.
Right, but what you're seeing on your screens right now is just some sort of summary of everything that's happened so far. We know that President John Dramani Mahama, like Ben said, in accordance with Article 146 of the Constitution and in consultation with the Council of State. Now, this is very important because the commentary coming in sort of suggests that the president did this on his own. But it says that in consultation with the Council of State, determined a prima facie case and as established in respect of 3 petitions against the Chief Justice, Her Ladyship Justice Gertrude Araba Esaba Torkornoo. And our guest joining us for more details on this. Let me introduce our guest and then we continue with the slides you're seeing on screen. We have Nana J. Bafwewa. He's a lawyer and member of parliament for Misha South. And we also have Nana Kofi Safo Kantaka. He's also a lawyer. Gentlemen, good morning. Just to test and be sure that we can hear you.
Yes, good morning. How are you doing, my? I'm
fabulous. Thanks for asking. Is this Nana J. Bafwewa?
Yes, please.
Okay, do we have Safo Kantaka as well? Okay. Kindly unmute so we can hear you. All right, so what you're seeing on the screen, let me continue with that while we try and connect with our guest. The president has consequently established a committee in compliance with Article 146 of the Constitution and in consultation, I think we've done this already, following the composition to inquire into the petitions which have been brought against the Chief Justice. Now, this is the panel, Ben, and this is where an interesting detail lies in terms of the people who are going to be sitting on this panel. We have Justice Gabriel Scott Kwamang, Justice of the Supreme Court. We have Justice Samuel Kwame Adibuaseju, Justice of the Supreme Court. We have Daniel Yaw-Dumelovu, and I heard you this morning about how it might be controversial that he's sitting on this case when the Supreme Court has dealt him, should I say, a heavy blow in his time of trouble. We also have Major Flora Bazwarunura Dalugo. He's from the Ghana Armed Forces. Very little is known about this person. I don't know, Ben, if you know anything about her.
Not much.
We have
honestly. Professor
James Sefa Jisa, Associate Professor, University of Ghana. So this is the panel, the 5-member committee that will be probing that prima facie case that has been established against the Chief Justice. And so pursuant to Article 146, Clause 10 of the Constitution, and in accordance with the advice of the Council of State, the President has, by a warrant, suspended the Chief Justice with immediate effect, pending the outcome of the committee's proceedings. And that's what we'll be discussing this morning because minorities come in with their reactions. And I want to start with you, Nana J. Bafwewa. How did this news come to you?
To be frank with you, we knew this was coming. Why? How did you know this was coming? We knew it was coming because of comments that had been made by very senior figures, the ruling government, right, the ruling party. And so we knew it was coming. However, right of that, given the gains that we have made since 1992, right, we were going to see some tolerance, right, and if you like, moderation, in terms of how we handle things. And so some reason was going to prevail at some point. And so if you observe, in all my public discourse or commentary, I kept urging caution. It was the very reason why I kept urging caution, because I thought that there would be reasonable voices, right, in the midst of the demands by the hardliners who would have reined in the call for what we have seen, right? Before the NDC came to office, it was without a doubt that they had some grievances against the judiciary.
And what are you inferring this from?
Pardon?
How did you arrive at this conclusion?
it's common knowledge. Statements made by senior members of the party, including the president himself, at the NDC Lawyers Association conferences. This is common knowledge, very respectfully. I mean, there are copious evidence to that effect. Indeed, their grievances was not just against the judiciary, it was even against the Ghana Bar Association, to the extent that they deemed it necessary to even register, right, another lawyers grouping. Subsequently, then they had the NDC Lawyers Association, which was also having their conferences from time to time. And so you can tell a certain level of bitterness in them. But I have always believed that, look, this is a democracy. This is a democracy. This is a constitutional democracy. When you have the power, you don't go for short-term gains. You look at transforming the system to make it better and not to suit you. And so in all this discourse, I kept urging that let's be cautious. Even if you are not happy, let's pursue reforms. Luckily, you are undertaking constitutional reforms.
All right. So
why don't you, right, consider reforms that would be to the that would inure to the benefit of not just the present but also future generations. So it was expected, given the conversations that had gone on in public by NDC leading figures, and subsequently by when the NDC, when the president was sworn in, as recent as last week, we all saw interviews by senior members of the party. General Mosquito, the chairman of the NDC, Mr. John Kennedy Dunketia, in interviews that have been circulated widely. We have also heard Mustafa Bandi, right? You cannot.
Well, we will get incisive with the conversation. That's your initial remarks, and Ben will come in shortly. But let me also take initial comments from Nana Kofi, Safo Kantaka, and then we get the conversation going. What about you? What's your initial reaction to this developing story? Nana Kofi, Safo Kantaka. Kindly unmute for us.
Very well. Can you hear me now?
Yes, loud and clear.
Yes. Good morning to our viewers. Yes, if you ask my initial comments, as lawyers, we and even citizens of this country, we would have wished this never happened. Yes, we would have wished this never happened, because we have three arms of government, which are the executive, the legislature, and the judiciary. Each of these arms of government is independent. So for us to get here as a country, as I said, I would have wished this never happened, because it doesn't send a good signal to our democracy and to our governance, even though the processes the president has embarked on is constitutional and all that. The optics are not good. It doesn't look good for the country and for all watching citizens or observing citizens. It doesn't look good. So if you would have asked of my initial comments, that's my initial comment, that we wish this thing wouldn't have happened at all. It doesn't look good.
It does not look good, and I do think that no person would want these things to happen, that the heads of the three arms of government would be impugned. As media, as we're referred to as the fourth estate, we want to be protected. So all these protections are important. But is that to say that if there are infractions or if there are issues with any of these leaders, the law cannot be followed? As far as even the president, there are protections given a president, but that president is not immune to the law if he or she falls foul of it. Is that not correct?
That is very correct. I don't know why the basis of me saying it doesn't look good. As Lawyer Ua initially pointed out, what doesn't look good, as in the optics not being good, is that it's based on the previous comments. It gives us some sort of colorization. If President Mahama hadn't have hadn't come out with his comments with the NDC lawyers and then being voted into power in 2025 and then embarked on this exercise, would have been some sort of independence. The optics would have been good. But the previous comment by the president, then candidates with the NDC lawyers, gives it some sort of colorization. So anybody at all can impugn some of these motives within the constitutional process he's embarked on. That's why that's the basis of me saying it doesn't look good. Yes, because it's giving people, even as Ewa is saying, and even non-lawyers and even ordinary citizens are even just impugning all these thoughts within the constitutional process. Yes, it looks as if, fine, there has been an allegation or a petition against the Chief Justice. Fine, we will come to power, even though we've made all these comments. We've come to power, but we shouldn't make it look as if we are using the Constitution to achieve a political aim, which has its undertones from the previous comments I earlier alluded to. So the basis of me saying it doesn't look good is based on the colorization which has been given to the process. So it doesn't shy away from anybody who has infringed the provisions of the Constitution for a petition to be brought against that person, a person to be passed through the constitutional process. Nothing stops any authority from basing his actions on the constitutional process. But then the previous comment is giving it some colorization.
All right.
To the process. Yes.
We'll address that specific issue when I go back to Lawyer Bafo.
Yes.
But let me just ask you, so far, in terms of due process, the letter of the law being followed to a T, is that being done, or do you see something else happening?
From where I stand, I don't see anything wrong with the constitutional process. Well, right from the start, the petition was sent to the president, and the president, in consultation with the Council of State, have established a prima facie case. Before the establishment of prima facie case, the president, the Chief Justice, wrote to the president for copies of the petition to be delivered to her. It has been done. The committee has been set up with even the composition. There are no qualms to the composition. It has followed the qualification as ascribed to by Article 146. They have established the committee. Now the Chief Justice has been suspended as well by Article 146(10), although it is due to the discretionary power of the president for him to suspend the Chief Justice based on the advice of the Council of State. And as we all know, the advice of the Council of State, even though not binding on the president, as in the plethora of authorities, the president has exercised their discretionary power. So based from Article 146 down to Article 146(10), the president, there is no comes with the constitutional procedure. The president has established, and even if you talk about the exercise of the discretionary power, it is quite reasonable. You see, the Constitution also, interpreting the Constitution, we should also ascribe some form of reasonability to the process. How can the Chief Justice be in office and exercising her judicial and administrative power whilst a committee has been set up to look into the petitions against her? It doesn't add up. It only add up for the Chief Justice to be in position as Chief Justice and still be queried by the committee. It doesn't make sense, constitutional sense. So that's why the Constitution also, an interpretation and the provisions embedded in it, has ascribed some form of reasonability for her to step aside. And even the suspension doesn't mean removal. It's for her to just suspend her activities or her position, for her to go through all the inquiries. And if she comes out so clean, she assumes her position. And even the Constitution itself also makes provision for the president to revoke the suspension.
Indeed. So we'll get to all of those parts. And indeed, the Constitution makes room for that. So from where you said the suspension is right by you, right?
It's in order. Constitutional order.
Let me go to Lawyer Bafo. I heard you talk about reasonable voices. The Council of State has its role in advising the president at any given time on establishing a prima facie case, among others. When you speak of reasonable voices, are you saying these people did not apply reasonableness in arriving at this decision, this prima facie case that has been established?
I don't think that is what I meant.
So please clarify.
I don't think so. Now, let me quickly respond to something. My learned colleague, Safo Kantanka, mentioned that the president has the discretionary power to suspend the Chief Justice under Article 14610, and that he has done it. And so what has been done is constitutional, and that it appears that all the boxes have been ticked. And so in that regard, it is constitutional. My learned friend perhaps may not have considered the need for Article 14610 to be read together with Article 296 and Article 23. Article 14610, to the extent that the president is exercising the discretionary power, is regulated by Article 296 of the Constitution, which is mandatory, especially 296C, which requires the pre-existence or the pre-publication of a regulation in the nature of a constitutional instrument or a legislative instrument to govern the exercise of discretionary power. That would have given the process predictability ahead of time. And it is mandatory. The president is not exempted from it. The only two persons or group of people who are exempted from it are judicial officers and judges. As we speak, when you are given the power, right, a discretionary power is discretionary.
For the sake of this angle of the conversation, if I may, let me read 296, and then you can continue from there, just to clarify. It says, where in this Constitution, that is the 1992 Constitution, or in any other law, discretionary power is vested in any person or authority. A, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased, whether by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. And C, where the person or authority is not a judge or other judicial officer, there shall be published by constitutional instrument or statutory instrument regulations that are not inconsistent with the provisions of this Constitution or that other law to govern the exercise of this discretionary power. Has any of this been flouted?
There is no regulation in place for the exercise of the discretionary power which the president has under Article 14610. There's no such regulation in place. Now, my brother said that, my learned colleague said that it is only reasonable that in the circumstance the Chief Justice is suspended. If the framers of the Constitution were of the view that in such a circumstance it was automatic that the Chief Justice would be suspended, it wouldn't have made that power discretionary. It would have made it mandatory.
But the fact too that it is not mandatory does not mean, while the power is given to the president, again, in consulting the Council of State, they will come through with that. I'm not getting your point. The fact that it's not mandatory does not
if you allow me to talk, you get my point.
Okay, go ahead.
If you interrupt very respectfully, you will not get it, and you say you are not getting it.
Please go ahead and land.
It is not for nothing that discretionary power is regulated. It is regulated so that there will be certainty, there will be predictability ahead of time. So that when Benjamin Akapo, right, is facing the potential exercise of discretionary power, before it is exercised, Benjamin knows the circumstance under which it will be exercised. And so all of us as citizens will know the circumstance under which our Chief Justice will be suspended. So we sit here. We don't even know that circumstance under which the president decided to exercise that, discretionary power. It is even more necessary given the fact that this whole process is in camera. So we should not be surprised as citizens that we don't know the circumstance under which the Chief Justice will be suspended. You understand? That is the essence of Article 296 of the Constitution. Now, when there is a regulation, right, that duty could be fair and be determined whether in the circumstance of the exercise of the discretionary power there has been fairness, and that the duty imposed on the person exercising that power, in this case the president, has been performed. How do we know if it has been performed? Right? Because there is no regulation. You understand? And so, in the circumstance, right, it can be challenged. Look, we are talking about the impeachment of the Chief Justice of the Republic of Ghana, right, by the executive, by the president. Okay? I mean,
let's you see, these are some of the wordings that is it the president, because as far as the processes are concerned, petitions are brought, and I'll be coming back to Sweetie Abochi shortly. Processes are triggered by way of petitions. In fact, even before these three, we had the one from last year, Professor Kweku Azar. Processes are triggered. The law is clear. When Mr. President receives the petitions, he forwards them. The Council of State then comes through. The same way under Akufo-Addo, they said that for Professor Kweku Azar's petition, it lacked merit, and so no prima facie case was established. In this instance, a prima facie case has been established. Then the necessary process, according to the law, is the setting up of this committee to delve into the matter. And again, the president, per the Constitution, may suspend the Chief Justice. Where exactly has the illegality taken place?
What do you mean by the illegality? Because I've done a lot of analysis.
You are saying
illegality, so that our
illegality, my word. Illegality, my word. Okay, not yours. But you suggest that
because you see, illegality has a definition, and so when you use the word illegality, very humbly and respectfully, right, it should be in reference to something, so that very respectfully, in responding to you, I know what area I should address you.
You are very right. Let me couch it this way. You seem to suggest that something has been done that should not have been done, or at least there's some problem with the process. I just want you to pinpoint for me. That's why I went back to some of these processes.
The lack of regulations to underpin the exercise of discretionary power. Nobody has been able to deny the fact that there is no regulations. Nobody is denying the fact that under Article 296 of the Constitution, a regulation is required. Nobody is denying the fact that under Article 14610 of the Constitution, the President is exercising a discretionary power. So in the circumstance, right, it should be exercised in consonance with 296, right? The fundamental question that we all need to answer is whether the absence of the regulation makes it fatal. My submission is that it is fatal. Some have stated that the case of Ransford France, the Assistant Attorney General and the Electoral Commission, right, doesn't make it fatal. I say that it is even made more fatal on the basis of the case of Ransford France versus Attorney General, where Dr. Barnes categorically stated that in quasi-judicial matters, there is the need for a regulation. And this is a quasi-judicial matter. Why is it a quasi-judicial matter? It is a quasi-judicial matter because it's a semblance of a court proceedings where a prima facie is being determined, where, very respectfully, a suspension is being done. And I will explain to you in very basic terms. Benjamin Akpapo, very respectfully, works at Joy FM. Benjamin Akpapo, right, have been, a complaint has been lodged against Mr. Benjamin Akpapo, right, for some misconduct, okay? Now, Mr. Benjamin Akpapo, right, is being suspended on the basis of that. When Joy FM has laid down procedure that requires that there should be a regulation in place before the suspension can be done. This is simple employee-employer relationship. Ask every lawyer. In the absence of that regulation, the court will find that the interdiction or the suspension, right, constitutes or is an unfair one. that is even basic. You don't even elevate it to the constitutional level. We are talking about the constitution of the land, where the established principle is that no man has the power or immunity. No court, even in this land, has the power to grant immunity for the breach of a statute, particularly the Constitution. You understand?
So what you're saying, just so we can move the conversation forward. So what you're saying is that it's not that the president couldn't have triggered Article 146.10, but that it should have been in consonance with Article 296. That's what you're saying.
It should have been in consonance with Article 296.
And you're saying devoid of that.
The ingredients or the elements that would be necessary to satisfy Article 296, right, are not in place.
Okay. Just in passing, you said something about what brought us here. The president, I don't think you used the word removing, but you seem to suggest that it was the president, technically doing this.
That was your interest. So no. So let's even go there.
What word did you use? Because you seem to suggest.
Then I appreciate the point. Let's even go there.
That it was the president doing this. That's why I went to the Council of State and the rest.
When there is a petition, in the case of the Chief Justice, right, is the president that initiates it. And that is why when you look at the communication that came out, the president stated that he has received the petition, right, for the removal of the Chief Justice. First step. Second step, he has commenced the necessary constitutional consultation with the Council of State. Second step. So without the president's steps, the Council of State doesn't even come in. So the president has a role in this.
Okay.
And that role, yes, mandatory, right? And so even when we say that the president has commenced the impeachment processes, it is not out of place. I'm not out of line.
All right.
Okay. Before we go to Nana Kofi Safo-Kantaka, I just want, because of some of the words you used, I just want to get some clarity on it. So you say this is an impeachment. It suggests an impeachment of the Chief Justice. And then you said something about definitions. But I want to take you back to the letter that the minority put out in response to this action, where you say this is a judicial coup. Because you emphasized on the definitions of some of the words we're using right now, I want to understand the elements of, because I think the cardinal value of the coup, or the definition.
We need to distinguish between politics and law.
Hold on a second.
Do you want me to speak to politics or do you want me to speak to law?
In as much as these are legal provisions, I know that there's political commentary running on the back of it, because at the end of it, this is a minority in parliament. This is NPP, NDC. So I just want to get the understanding clearly. So hold on for me. Let me ask my question. Hold on a second. So I'm saying that where in the processes that you've just outlined suggest a coup, bearing in mind that the definition of a coup, the cardinal value of that definition of a coup means it's unlawful.
The processes I outlined, right, are legal, is law. And let me stick to the law. Okay. If you want me to go into politics, you can invite me into politics and we'll do politics.
This is not politics.
On this program.
Yes. We are discussing the issue in totality. Just give me a second. The minority has written a letter, strongly worded letter, right, in response to this. And they use the word coup, a judicial coup. I just want to understand from your perspective what elements in the processes that's, at this point in the processes so far, signals a coup, a judicial coup. You cannot just say, you can't use a word like that. And I just want clarity, really.
The prior commentary leading to this process, the prior commentary, that's why I said I don't want to go into politics, because we are two lawyers. The other lawyer is not a politician. And so I wanted to be as a lawyer as possible. But if you want to go into politics, then this is the politics. The prior commentary before this suggests or is evidence of a predetermined mind by the ruling government to remove the Chief Justice. Right? And that is what is happening. Now, the president himself, in my preliminary comment, I stated it. The president himself made several comments to that effect. The chairman of the NDC, right? The most senior person of the NDC is the president. He has made those comments. After the president, the chairman of the NDC, Mr. Johnson Ketia, also stated that the Chief Justice will be removed, right? After him is the General Secretary, the Deputy General Secretary, Mr. Musa Fagbandi, has also made the same statement, okay? And so that clearly shows a politically predetermined agenda to remove the Chief Justice. Right?
Is this not politics? Is this still law? If you're bringing in the commentary from political actors as a way of
very respectfully.
Yeah.
Very respectfully.
I thought we're sticking to the interpretation of the law in educating the audience.
Are you now running away from your own question? Because I direct very respectfully, with the greatest of respect, before going this tangent, I cautioned you. And you still invited me. And I've done that for you. And you're now asking me, is this still politics? Why?
Okay,
you want to set a trap for me?
No, I'm not setting a trap for you. What we are doing is...
Let's mix... I think at this point, if we want to separate law and politics, sweetie, it's interesting, right? So let's mix them together.
See, we cannot discuss one without the other.
Let's mix them. Let's form an amalgam, right?
Yes.
Let's proceed on this level. I mean, I find it interesting that you talk about a predetermined mind, because you know that in criminal law, that has quite some consequences, right? In some respects, if a mens rea is determined. But these people you speak of, yes, you speak of Johnson Esidu Nketia, the chairman of the party, Mustafa Gbande, among others, stalwarts of the NDC, correct?
Yes.
Very prominent figures, correct?
Yes.
With a high level of influence, correct?
Yes. Why? Am I under cross-examination?
No, you are not. But
okay.
But with all this influence,
where are you leading me to?
You will find out shortly. With all this influence, are they in any way a part of the process that we are seeing? Whether as Council of State, please hold for me, because the court of public opinion or individual opinion is out there, and as a lawyer, you know that the court of public opinion and the court of law are two separate things. Public opinion is not supposed to and does not and should not influence a case in court or in any such situation. Is that true or not? Just give me a yes or no before you go on.
So please, let me answer you very respectfully, then we move on. You know, Shakespeare says, there's no art to tell the mind's construction on the human face, right? And as students of literature, we all know that if you want to know what a person is thinking or who a person is, it's about what the person said, right? Or what others say about him. Now, we will not know what the position of the NDC is unless their corporate representatives have spoken. The person that represents the NDC in the corporate scheme of affairs is the chairman of the NDC, is their deputy general secretary. The NDC is not a human being. When these people speak, they speak for the NDC and they speak the mind of the NDC. That said, who is the chairman of the Council of State? The chairman of the Council of State is the retired Right Honorable Do Ajaho, a full blue NDC man. Go and check the record of Mr. Do Ajaho, Speaker of Parliament. Go and check whether or not he was partisan and draw your own conclusion. Go and check.
Okay, so pardon my interjection. Yes, I will allow you. But pardon my interjection.
So let me land.
Pardon my interjection.
Go and check the composition of the Council of State.
To be fair to
wait, my brother, wait. You say you want us to mix politics and law. Go and check the composition of the Council of State. Look, when the Council of State elections were held in the Ashanti region, right, and Nana Nkansa was close to winning the election, what happened? The NDC was determined to ensure that the Council of State would be truly dominated by the NDC where they have control, right? Because the composition of the Council of State, some are ex-official positions, but where they have control, they will make sure that the persons are determined by the persons are persons from their womb. Okay, so the makeup of the Council of State is predominantly NDC. And the chairman of the NDC's position, you all know, the chairman of the NDC sits in cabinet. So this is a predetermined partisan position which is being executed.
So very quickly before we bring in Kwejoga Adawudu, but very quickly, you mentioned Dua Ajahu, of course, who has been a Speaker of Parliament. Are you saying that these people, when they come in, they cannot reason beyond politics? Because we apply the same standards to our justices of our courts as well. And someone would also say to you that, hold for me. Someone would also say that former member of the, a member of the Council of State.
Hello?
Yes. Let me just land. Someone would also point to you that, there's been Sam Okujeto, a respected lawyer, statesman, if you like, and his rhetoric in the past seems to suggest, as some people have said, that, he leans this way on the political sphere. Would you say that if he, at the time he was on the Council of State, if such an issue came, he would be partisan about it? Because then that's what you're suggesting with.
I will not be speculative on Mr. Sam Okujeto. I will not. Mr. Sam Okujeto.
But you can be speculative on Dua Ajahu.
Listen, I am a lawyer, very respectfully. When I am going to court, I will have to know the mind of the judge. When the jury trial, I will do an analysis of the jury, and I'm saying that I am profiling the Council of State in a matter. The best person I will profile is Mr. Dua Ajahu. How would I know the thinking or the disposition of Mr. Dua Ajahu? Very respectfully, is he a moderate? Is he an extremist? To be able to determine his position, I'll go back to his parliamentary records, because that is where I'll go through his profile. When we go through his profile, Mr. Dua Ajahu was a public servant, having worked at the Attorney General's office. Right from there, he went to Parliament on the ticket of the NDC. Right there, he rose to become the majority leader, if I'm not mistaken. Subsequently, he became the second deputy speaker or so, right? And later on, he became the speaker. If you recall the WikiLeaks, right? One of the things that came out from the WikiLeaks was that a former foreign minister of this country on the ticket of the NDC in the name of Madam Hamatete.
Okay, I think now we are going pretty far, and we have
profiling. I am profiling.
Okay, so please land on the profiling so we can move to Kwejoga.
No, you see, stated that even though Madam Bamford Addo is the Chief Justice, it will be the Speaker of Parliament. When it comes to very partisan matters, they will bring in Mr. Dua Ajahu. This will tell me who Mr. Dua Ajahu is.
Okay, so I guess it permanently takes away his ability to reason through matters. It must always be partisan. That is the point you're making. Sweetie, let's bring in Kwejoga Adawudu.
Yes, so thank you for joining the conversations. And by all means, give us your initial reaction. But this is my substantive questions to you. 2 points before I get to the question. So, Lawyer Bafwewa is saying that, well, like Shakespeare said, there's no way to show the mind's construction on the face, because political actors from the camp of the NDC have said things that suggest that this might be a personal vendetta against the Chief Justice. My question is, does it affect the process? This is like an intersection between words and action. The action that we are seeing following due process versus the rhetoric or commentary pouring in from both political parties. Where do we draw the line?
Thank you, Siti, and good morning to your viewers and listeners. I carefully listened to my junior brother, Bafo Ewa. This is what they do, and his argument is flawed. If you look at it, he never talks about the law, all he's talking about politics. So,
to be fair, we started with the law and somehow we got into politics. So he did mention some, yeah.
So I also tried to tell you asked him a question about my own grand uncle, Sam Okujeto, and he said he was not going to speculate. But he could profile somebody, but could not profile it. This is what we do. When we always say it is political, everybody knows everybody's intentions. everybody where he belongs. So if you want to pigeonhole, so how did my brother Bafo got to the University Council of KNUST and no other person got there until the change of government? So if you want to pigeonhole and profile, then everybody would say because you belong to this place, that's why. But this one, it is the law that dictates the procedure. And I think that we have just followed the procedure.
So are you saying that the commentary doesn't affect the procedure in any way?
At all. At all. Yes.
But it does carry some weight, does it not?
A procedure, and that procedure is being followed. And this is not the first time that procedure is being followed. With the outset of the Fourth Republic, we have seen almost all the Chief Justices or some of the Superior Court Justices going through that process. It got to a point when there is no prima facie case established, the process is truncated. If it's a prima facie case established against the group of people who that article governs the procedure, it goes on. We have seen Chief Justice Akwa has gone through that process that brought about the case of Ejetu. We have seen there has been a petition against Chief Justice Wood, Georgina Wood, which did not go through. There has been a petition against Chief Justice Sophia Akufu that the president, at the end of the day, did not act on. We saw a process removal against Chief Justice Enim Yeboah. There was a process against Chief Justice Tokonu, which the president said no prima facie case has been, and this is another process. So almost all the Chief Justice and Superior Court have gone through, and it was the same Article 146 that went through the process. But if he now wants to pigeonhole and bring in about political actors, yes, I agree with him at the point. What people say, political actors say, and it eventually comes to pass, that is when people would say, yes, this is what they said, and this is what has come to pass. Of which I don't ascribe to, that when you are a leader or you find yourself in a political space, what you say would come and haunt you.
All right, Mr. Adawudu, quick interjection. Mr. Adawudu, yes. Quick interjection. Benjamin here. On the other hand, while I have, made mention of the fact that the law is what it is, and all of these people who may be speaking from party angles are not a part of the process. On the other hand, what does it do for the optics when people as prominent as a chairman of a party and some deputies, also wade into it and speak openly about the fact that, if you want to put it mildly, it serves her right and that this may actually come to pass? What does it do in terms of the process?
Yes, exactly. That is, sometimes it doesn't help the process. Because, yes, you can see that this is the process. And for me, where I sit and where the law sits is that nobody knows the content of the petition. Even up to this day, nobody knows the content of the.
I have heard some people on some networks claim to know certain things and sums of money used here and this and that. In fact, there's a broadcaster, and I don't know, that's where leaks and all of that come into the fray, who are seemingly analyzed about 3 or 4 of them. How did that happen? So if you say nobody, it appears some people do.
Yes, if they do, the law says that you don't need, the petitioner cannot make it public. And once it's even given to the president and the committee, the content cannot be made public. So I'm sure there's speculation, conjecture, and they may have gone in to see, maybe when they are talking about some money, maybe something has been captured in the auditor's report, which is in public domain. So if people go to find out few things that may have happened in the auditor's report and say that this is what they think will be the content of the petition, I'm sure by where the president is with advice he's going to get from the council to the president and council of state, there's no way that content could be made out to the public. So, yes, I agree that sometimes when the political actors, what they say and where they belong to and they speak, it makes things difficult. It makes the process. But at the end of the day, it is the law that dictates the process and what has to be done. People should understand that this is suspension. It was a discretion granted the president that he may, while the committee is formed, may suspend. He can decide not to suspend. But I'm sure the advice and in the wisdom that has been provided and as advised to him, he feels that she should be suspended. It doesn't mean that she's guilty or not. It is now that the process is going to be opened up. And once the process is opened up, she will be granted a lawyer of her choice and any other aspect of her choice when she's given or as she's been given. And I'm sure she has also prepared to go to the committee and meet them. So let's allow the process to go on. Unfortunately, you say that the Council of State, we have the former Chief Justice over there. So I would say the former Chief Justice is an NDC because she was appointed.
Right.
Again, so once we try to pigeonhole people, when it comes that their people also have to be profiled, as he said, he was profiling, they always want to stick the goalpost. And I think that, yes, it is granted because they are in politics, they are political actors, they have devotees, they have the grassroots, and they want to speak to a target audience.
Quick point. We're trying to do law here, not politics, as much as possible. I'll cede to Sweetie Abochi shortly, but I just had to come through with this. Lawyer Bafwewa has said that, and it may not necessarily be on this show, on UTV, he said that this was unconstitutional, what was happening. In fact, if I may quote what he said, suspension of the Chief Justice is unconstitutional, he said. And he shared some thoughts on 146 linked to other articles of the Constitution. Martin Kpebu, when I listened to him yesterday, he made mention of the fact that previously, and some said he was being political or because it was Nana Addo Dankwa Akufo-Addo as president, had made mention of some of these processes and how the executive had become too powerful and maybe it could be weaponized. Is it high time we decouple the executive, our presidency, from some of these issues to avert some of what we are talking about? Oh, party members said this, so likely it is that channel that is being followed. Do we have to decouple the presidency or the executive from some of these processes so that it appears more neutral? What do you think? That's my bid to you for now.
Yeah, I think that we have, as people, we have decided that we want to do constitutional democracy, and the Constitution is what guides us. If it is the view that we have practiced, we have used this Constitution for the past 30 years, and it is not serving us well, or there something has to be done by the procedure, I'm sure the Constitutional Review Committee is working, and we should put a memoranda or put the ideas together so that they can have it and look at it. That we think that the process by which the president can be removed, we think that it is obsolete, it is outdated, but to say it's unconstitutional, I totally disagree. That is the Constitution that we are following. And if we have to do a review, thank God, the committee, which is chaired by Professor Premfe, they are working, and we can put it before them that we think that it should be more tighter, safer, and the procedure by which justices of the Superior Court will be.
Mr. Dawudu, for the sake of time, I think your point is made. Sweetie?
You know what they say, Ben? Justice must not only be done, but to be seen to be done. And the optics are very important, because when you have political actors, like yesterday I listened to Dr. Tanko Computer saying that they are happy about this suspension and all that. Perception shape actions, inactions, and all that. And so the judiciary must be seen as a strong arm of government. And if we are, pouring these commentaries in as much as it doesn't affect constitutional processes, I think we should be circumspect. The question I want to ask, what does this do to that case in the Supreme Court? We're supposed to hear, I think they were supposed to sit on the 6th of May. What does the suspension do to the case?
Sidi, I think that the Constitution grants power to all branches of the government. It has granted power to the president what he should do. The Constitution, the same Constitution grants power to the Supreme Court what they should do. So I'm sure they will do what the law allows them to do.
Yesterday, I listened to Justice Remsai, and he says that only when the case has actually been heard in court on a particular case or an active application can it stop a constitutional process. I'm trying to understand whether or not this case has been, nullified, or if it's still an active case because the Chief Justice has been suspended at this point.
At the end of the day, interpretation of the Constitution is within the confine and province of the Supreme Court. So I'm sure the case, the Supreme Court can look at it and say that it has become moot, or we think that there is a point that may come with the procedure that we are talking about that we don't think it is serving us. So the Supreme Court can say that, yes, we can take on this matter and make sure we fine-tune the procedure by which any justices or the Chief Justice can be removed, just as they did in Chief Justice Akwa's time by coming with the AJ2. So the court will decide in its wisdom whether we will continue and fine-tune the process or we would just terminate this. But I think the suspension of the Chief Justice does not make her removal total until they go through the process. So it will be the Supreme Court that will decide what they want to do.
Okay.
Next.
And two last questions. I'll just lump them into one. I've heard other lawyers say that to save face, the Chief Justice should just resign so that all this can just go smoothly without the ruckus we are causing right now. And the second bit would be, okay, do you agree that the Chief Justice should resign at this point to save face?
That is a decision for her to take. I think that what she has said and the number of years that has to be served, she's done. And I think that for her, if that is her peace, that will bring her peace and go untainted. And I think that is an option for her to exercise. Also, another option for her is to say that, no, I think that I have to stand and I haven't done anything I'm being accused of. And I need to prove my point that I am clean. Nothing untoward has happened. And at the end of the day, whilst I have cleared my image and everything, I can make a move. So I think it's entirely a decision for her and her family to make.
And because there's a pending case, do you think that the president should have waited a bit to, see how that case is concluded before proceeding with the suspension? In effect, are we jumping the gun over here? I listened to one of the lawyers on Newsfile over the weekend and said we shouldn't jump the gun. Is that what is happening here? Are we jumping the gun?
No. I don't think so. It is a power given to the president under the Constitution, and he has exercised his power. So that power is exercised. The judiciary also has been given powers to exercise. Parliament has been given powers to exercise. So if all are exercised in accordance with the Constitution, there is nothing wrong to say.
But these powers don't come with timelines. I guess is the thought I have now. A little delay would not have affected the case in any way, affected the removal or suspension in any way, would it have?
Let me maybe take you back. When the Supreme Court in the Muntie case exercised their power, and another power has been given to the president, and he says that I'm giving parole to the people. They all exercised their powers. And at the end of the day, it was right. They did the right thing in accordance with the Constitution. So I always say the law grants everybody. It depends on how it is used, that
right.
The perception will look at it that it's being done for good or it's being done for evil.
Right.
But what the law dictates is what is being done.
Mr. Safu Kantanka, let me come to you. I am curious about your take on the committee that has been formed. And let me just take a few seconds to walk you through this. So Justice Bafo-Boney, who is now acting as Chief Justice, is the oldest on the Apex Court, brought in 2008, came in with the likes of Justice Eni Nyabwa and some others who have now gone on retirement. This was under Kufuor. He was the deciding factor in the 5/4/2012 election petition loss for the MPP's Akufo-Addo then. And all of this has been brought into the fray because his wife is also Patience Bafo Bonnie, someone who has done some 30 plus years at the prison service. The claim is that, politics came in and she wasn't given certain roles. She's now Director General of the Ghana Prisons at Service. That is Bafo Bonnie. Then you get to Daniel Yao Domelevo, who also had that infamous case where later his request to proceed on leave was deemed illegal. Interestingly, that declaration of illegality was done under Gertrude Tokonu, the now suspended CJ. You have the next in line when you look at the committee, Justice Gabriel Scott Pwamwang. He's Justice of the Supreme Court, and he is next in line by way of age on the bench or time served. Then you have Justice Samuel Kwame Adibu Asiedu, and then you have Major Flora, and then Professor Sefa Jisa. When you look at the composition, some have said that the likes of Justice Bafo Bonnie, who is acting as CJ, the likes of Daniel Yao Domelevo, there could be some influence there. What do you see from those angles?
Yes, I think that's very telling. Yes, my comment on it also buttresses the point of the optics not being good. Yes, and the colorization we've been talking about. You see, having Mr. Yao Domelevo on the committee sends some signal, because the commentaries we've been hearing is that having Yao Domelevo on the committee connotes some sense of a payback time.
But I also just mentioned that it was under Gertrude Tokonu, wasn't it, that this illegality was actually proclaimed, that his being asked to proceed on leave was illegal. It started, I believe, under Justice Enini Abuas, then Chief Justice, and ended with Gertrude Tokonu. And it was under Gertrude Tokonu that it was deemed illegal. What would that do?
You see, the pronouncement of it being legal, I would say, is neither here nor there. The point being pushed is that, fine, the Supreme Court thought it was illegal, but then the timing. Why wasn't it declared illegal earlier for Yao Domelevo to have his way? But then the commentaries we've been hearing is that, fine, it was delayed and all that, and now even you see the Yao Domelevo won, but then it looks as if it's a pre-victory for him. So he being on the panel now, it suggests that it is a payback time. So
you're suggesting that if he has an axe to grind, this would be a good place to grind it. But this is someone who has served nationally, internationally. You're saying that you don't think he can reason beyond his feelings, his emotions, his hurt?
Yes, you see, that is beyond a point. And the point is we are advancing is the optics. If you just staying by the optics and then the previous comments and now bringing him on board. You see, you remember last year during the Supreme Court hearing, when the judges were empaneled to hear the case in relation to the vacant seat, the NDC or the speaker, the lawyer for the speaker, raised an objection to one of the justices. The fact that he has been a parliamentary candidate of the New Patriotic Party before. One would also say, is he not a qualified justice of the Supreme Court to sit on the matter? And for that matter, there are other Supreme Court judges. So what can he do? What else can he do? He being just one person. So we are talking about the optics. The same principle applies here.
Let's do the same optics for Justice Bafo Bonnie. Brought in under Kufuor in 2012, ruled he was the deciding factor in Nana Addo Dankwa Akufo-Addo and Dr. Bawumia losing their election petition. How about him? What do you see there?
Yes. Beyond that, the commentaries we've been hearing, if that is true, from other media, is that Akufo-Addo hounded him, was on him whether he will resign and all that, from people whose words carry weight. You get it? Yes, we've been hearing issues about the relationship between Bafoboni and Ekufuado. He telling him whether would he resign. He's been on him several years and all that, and then bringing him on board as the acting Chief Justice. Fine. You see, he's the senior most on the panel. For his part, I won't comment so much because he's the next senior most on the bench, and automatically he would be the acting Chief Justice. Automatically, for his side, I have no much comment to say on that. But then the panel, in respect of Yaudomolobo, if the issue, the petition, some the issues embedded in the three petitions has got to do with some sort of auditing, I will ask, can't there be any auditor in the country to replace Yaudomolobo for the sake of the optics and the previous comments? That's all.
Okay, so we are ending the conversation, but the same analogy you made when that justice of the court was brought in, and some people said he was a former MPP parliamentary candidate, and you said that, are we saying that for the sake of that, he can't, sit on the case? I could throw same to you that because Daniel Yaudomelevo had this incident with the judiciary, are we saying that he can't be a member of the committee logically? But that's a question that we can all answer. Thank you, gentlemen, for joining the conversation. Sweetie?
Yes, I just wanted to get a quick reaction from you. Do you think the Chief Justice should resign? Yes or no?
No, she shouldn't resign.
All right, she should fight it. Fight on. All right, great. Thank you all so much.
And there's one last thing I completely forgot. So let me just put this out there. Any one of you that wants to answer, 30 seconds for that person, only one person. Apart from clearing your name, and we saw that with James Jachikwason, for example, when he turned down the current AG's, olive branch to terminate that case. He wanted to clear his name. Apart from wanting to clear her name, the Chief Justice, if I say this cautiously, if it got to the point of a removal, if we got there, what would it take away from her in terms of what is due her legally? Any answer to that? Any of you want to hazard something? That's the very last question. Any of you?
Let me say this. The office of the Chief Justice need not be personalized. And so when you are in that office, you don't fight for yourself, but you also fight for the office and ultimately the Constitution.
Right.
And so for those who are saying that the Chief Justice should resign, they are personalizing and reducing the Chief Justice to Stockholm. It is the office for posterity. It's for posterity. If we are not careful, this will repeat again.
All right, I get that point, but please, I get the concept of the office, but I'm saying personally, what happens? Do you lose any benefits in any way? Do you lose anything materially or otherwise?
It's not something I've affected my mind to.
Okay, all right. Thank you, gentlemen, for joining the conversation. We had Nana J. Bafwe, he's a lawyer, also member of parliament for Manchia South. We had Nana Kofi Safo-Kantanka, a lawyer as well, and Kwejoga Adawudu, also a lawyer. Sweetie.
Well, thank you. You want to stick and stay with us. There's still so much more coming your way. And you know that we do a review of the 2025 Kwewu Business Forum today. We'll take a look at the fallout and how we want to handle that going forward as a nation. Please stay. The AM show is sponsored by Waylead Properties, providing quality housing at affordable cost with flexible payment options. Are you thinking of a rewarding investment you can engage in? Then Waylead Company Limited is your preferred choice for such investment. Waylead Company Limited is a real estate company with several developments to its credit right here in Accra. And you want to invest in Willow Lane. It's their new development where elegance meets tranquility. And they provide quality housing, like I mentioned earlier, with affordable costs and flexible payment options. At Waylead Properties, you get 24-hour security, reliable power supply, and other social amenities to make your stay a memorable one. I know you want to call us, so here are the numbers: 0240-111-119 or 0504-499-999. You can also visit our website at www.waylead.org. We'll take a quick break. When we return, more action on the AM show.